What is blind justice? The principle of blind justice was first catalogued in ancient Rome within the Eastern Roman Empire. Written in the Digest of Justinian circa the 6th century, the edict "Ei incumbit probatio qui dicit, non qui negat" was written, attributed to 2nd and 3rd century jurist Paul. This edict, roughly translated, means proof lies on he who asserts, not upon he who denies. This burden of proof being placed on the accuser and not the accused is what modern courts have come to know as a presumption of innocence, which forms the backbone of the principle of blind justice. The term blind justice itself comes from many things, but the most notable example would be of Lady Justice, the personification of the Roman god Justitia, who is shown holding a scale and a sword. In most interpretations, since the 16th century, Justitia has been shown blindfolded, with the intent that her judgment, represented by her sword, be based not on what she sees or preconceives, hence the blindfold, but instead on what evidence is weighed, represented by the scale. To truly understand blind justice in greater depth, however, we must not look at it merely through the lens of presumption of innocence, but through an understanding of individual rights, a topic for a later video, but one we must touch on here. The purpose of blind justice is to ensure that, no matter what, all individuals are held to the same standard of law, that this legal precedent should be upheld among each citizen. This guarantee should be no less and no more for any person than any other. The other important half of this principle comes from Blackstone's ratio, a term coined in regard to the man who first expressed it in legal commentary. Jurist William Blackstone, in his seminal work Commentaries on the Laws of England, published circa 1760 or thereabouts, has this to say about the presumption of guilt or innocence. All presumptive evidence of felony should be admitted cautiously, for the law holds that it is better that 10 guilty persons escape than that one innocent suffer. And Sir Matthew Hale, in particular, lays down two rules most prudent and necessary to be observed. 1. Never to convict a man for stealing the goods of a person unknown, merely because he will give no account of how he came by them, unless an actual felony be proved on such goods. And 2. Never to convict any person of murder or manslaughter till at least the body be found dead, on account of 2 instances he mentions where persons were executed for the murder of others who were then alive but missing. The most prudent part of that passage being that first statement: all presumptive evidence of felony should be admitted cautiously, for the law holds that it is better that 10 guilty persons escape than that one innocent suffer. Founding father and second president of the United States John Adams, a man who studied Blackstone's writings, had this to say on the matter. In the trial of the British soldiers of the 29th Regiment of Foot, a record of a court case in which he served at the time as defense lawyer for the accused. It is more important that innocence should be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world that all of them cannot be punished. When innocence itself is brought to the bar and condemned, especially to die, the subject will exclaim, "It is immaterial to me whether I behave well or ill, for virtue itself is no security." And if such a sentiment as this were to take hold in the mind of the subject, that would be the end of all security whatsoever. From this we can understand the fundamental underpinning of the presumption of innocence, as well as equality under the law. These 2 necessary parts of blind justice provide not only the equal measure for all of us to be judged by, but also fundamentally underpin the safety and security that we all feel in knowing that our criminal justice system is working. When these maxims are ignored, or worse, when they fail, honest and good people are not only cheated, but the very system by which we rightly judge the world is undone, leaving those who labor beneath the authority meting out justice feeling as though there is no safety for them regardless of what they do, therefore encouraging them to take part in illegal activity and subverting the law of the land to their own end. Law is an immensely difficult and robust topic of human interaction. It can be hard at times to understand the individual justifications, motives, and guiding ideas behind laws and practices that have been put into place. But these guiding ideas, this formulation of blind justice, is the cornerstone of modern legal precedent, the most important part to remember and hold on to. Without it, we are lost in a sea of tyranny, selfishness, bribery, and deceit.